a NERC should exhibit. The first is transparency, and what it means is that the factors that determine these processes that it goes through, the factors that determines his decision making should be clear to everyone concerned, and it should be open. I think it does well, somewhat well in terms of the requirements of the process. It's fairly open. We know what it should go through. What's a bit more difficult, and that might be a cause for a bit of concern, is the question whether or not it does follow through these processes like it says it should. For example, its licensing regulations require that a yes or no decision on the license application should be made within 6 months of submission. But I've been through a licensing process that took us 2 years before the license was eventually granted in any case. And so, but the requirement is that the process should be clear. NEC does issue regulations that are meant to guide what it does and how it will do it. The question is whether or not it's always follows through on those regulations. Also, there's a requirement for consistency of behavior. Treat all generators equally, treat all applications in the same manner. Again, I'm being careful not to appear to be critiquing the NERC, but at times it does appear that, and yes, as we go further down, you'll see that we're also saying it should be flexible. It does appear that as the industry evolves and moves on from a position, the regulator isn't sufficiently clear in communicating the reasons why the standards that are applied in the past no longer apply, so that it might lay itself open to somewhat open to a charge of not being consistent. Like I mentioned yesterday, I'm fully aware that there's several, probably many tens of IDN applications before the commission, but beyond opening the first, beyond issuing the first, maybe 4 or 5 that it's issued, it does not appear to be minded to issue many more, particularly when the application, where the applicant intends to operate within the network of an existing distribution company. Also, NEC should consult with industry participants and all stakeholders, customers, you name it, in issuing regulatory instruments. And on this point, I'd say that I think the regulator scores quite highly. It would rarely issue a regulation or make a binding pronouncement on industry without some form of engagement, first with the operators, but also with customers and other parties that might be involved. It probably also does a bit too much consultation with government, because very often we see what should be purely independent regulatory positions being, in my view, affected by what the government of the day wants. It's important that it communicates its decisions, the principles that guide it, we've talked about openness, but also in a timely and accessible basis for all interested parties. And I would add, I believe, that NEC's website is actually a treasure trove of information. There's almost nothing that anyone needs to understand how NEC will react or what it will do that you will not find on NEC's website. It tends to be fairly up to date, very often within a few days or even a few hours of a regulatory decision or instrument being passed. It shows up on the NEC website. I encourage everyone that practices in industry to visit that site maybe once every week or every other week, just to understand what are the new developments, what's going on, what's the regulator doing. It's also important, in my view, for the regulator to be flexible and to essentially, we're in an evolving market, a market that's one, challenged, right, but that's also developing and evolving quite rapidly. So it's important for the regulator to understand that it can't be a one rule for all situations, or a one size fits all approach won't work for this market. So what's important is that there's sufficient flexibility in the system to enable regulatory instruments or actions to be adapted or applied as required by changing requirements. But the corollary to that also is that there's a need to balance that with what I'll call consistency. So yes, if we were in a place a year ago, and on the back of that, we issued certain regulations or certain pronouncements as to how we treat a situation. If, in the light of subsequent developments or having seen how that has evolved, it will be necessary to essentially be able to dial back that approach, but to communicate it very clearly and openly as to why we're changing. One particular, this for me is actually a very important point for the reason that we're in an industry that, yes, we've done the privatization happened in the successor companies, Gencos and Discos, were handed over to the private sector in 2013, right? That's just barely November 2013, actually. So that, if my arithmetic is correct, is 7 or 8 years ago. It's a very young industry, right? In terms of where it needs to go, what needs to happen, participants, operators, customers, understanding what's the regime, right? So my view is that it's extremely young, and everybody, advisors, operators, the regulator, we're all learning along the way. And so there are things that will get wrong, there are things that will get right. It's important to be flexible and to be able to adapt. That's why, in my mind, at times, the regulator tends to issue too many regulations, right? Because all of a sudden you bound yourself to say, these are how I'm going to act. It then turns out that the regulatory environment doesn't favor that. You either have to retract it, or as it's done in many cases, you leave it out there, or then you're doing something else. It's important that the regulator is flexible. Finally, in my mind, the most important part of the regulators, the most important feature that the regulator needs to exhibit is independence. And that's independence of, this is the usually difficult one, of government, independence of the operator, that's the investor, and independence of we, the consumers. I'll take this in reverse order. It's not the regulator's job to protect you and I. Although, if it does its job well, what will happen is that we are protected, right? It's not the regulator's job to advance the case of the investor, whether it be investor in a generating company or in a distribution company, or in a, we'll talk briefly about that in a moment, a trading company, right? Again, if the regulator does his job well, the interest of the investor will be satisfied. It's not the regulator's job to be a mouth or a spokesperson or mouthpiece or an arm of government. It's extremely important, although I'd say well nigh impossible in Nigeria, for the regulator to be independent of government and independent of political considerations. And I'll give a clear example that might get me in trouble in a minute, right? So the regulator should actually stand outside all these three parties, which are the three parties that have somewhat conflicting interests in the sector, and reach decisions that ensure that the customer gets a supply in the best terms possible. The operator is compelled to operate in an optimal and efficient manner, and but is also able to earn back whatever it's invested in the sector plus a reasonable return. It's also that should also then lead to government achieving its objectives, which will be the same as what the customer wants, i.e. supply on the most efficient and least cost, in the least cost manner that will deliver a reasonable supply. Well, what we've seen here is, and we all know, right, once we talk about, in speaking yesterday, my view was a major part, not all of it, but a major part of the failure of the sector to be successful to date is the fact that the distribution company is not able to collect enough money to meet all of its costs. The question whether it's operating efficiently or not is a separate one that we don't have the time to delve into. But ultimately, what it needs is a higher tariff. Around 2015, when the MITO 2.1, I believe, was being passed, all industry participants and NEC kind of agreed that the tariffs were somewhat okay and were fine, and everybody was ready to live with it. But to my mind, now this is me speaking for Shola Refino, elections were approaching. There were plenty of comments as to the numbers were not right. There was pushback in government, as there always is in government. And the regulator panicked and then revoked that order and said, okay, we're going back to the tariffs before we issued that the MITO. What was the effect? Virtually all the distribution companies declared force majeure and said, oh, government has not met its obligation to give us a tariff that works. Until today, we haven't gone into a place where the discos and government kind of agree that the tariff that's in place, sorry, the discos and NERC agree that the discos in place work. So in my mind, the singular most important characteristic of a regulator is independence. You are an arbiter, an impartial arbiter, looking at all these parties and trying to figure out what works best. And the investor is not the enemy of the people. Nobody will put any money in any business without an assurance that well, at least a reasonable assurance that it will earn back what is invested plus a reasonable return, right? For me, it's extremely important. So having set this context for what the regulator will do, we'll just spend a minute talking through the licensing process. And the way I've decided to, excuse me please, the way I've decided to approach this is to talk through a chart that outlines next licensing process as provided for in its licensing regulations, right? As we're talking through each cell or box or diamond in the process, I'll try and speak through, because what a lawyer needs to know is that, okay, what's the commission likely to do? Why is it important? What are the issues that I need to be aware of, right? I'd also will speak to a little bit of an amendment that over the past year or two, NERC has made a change to in this process. So I apologize in my slides, this particular slide is a bit dated, but I'll speak to that in a minute. So essentially, the first part is that your client, right, needs a license. And so it decides that it wants to do business that requires a license. And we've spoken, again, the activities that require a license under the Act by section, okay, I'm not going to quote the wrong section. I think it's, I'm not going to quote the section. I think it's 66, but I'm not 100% sure. Sorry, apologies. So there are 4 activities that require a license. One is generation in excess of 1 megawatt at a location, but excluding captive generation. So captive generation is defined by the Act as generation that is used exclusively by the party generating and is not sold to a third party. So if I have a factory that requires 10 megawatts and I'm generating power for that factory, or even 100 megawatts, by law, I'm not required to have a license. What the regulator has then done is to say, in that case, I should come for a captive permit. And so it issued captive permit regulations requiring self-generators to obtain captive permits. I think that's wrong. If I was generating 200 megawatts of power for my own use, I will not go to a regulator for a captive permit, because those regulations are clearly beyond the remit of the regulator. The EPSR is quite clear that I'm required to get a license only for generation that I intend to sell to a third party. So that's the first bit, was generating more than 1 megawatt at a location. What that also means is that if, for example, your generating equipment is rated or is less than 1 megawatt, say 900 kilowatts, then there's no need for a license. 2 is the activity of transmitting power. which is moving power from generating plants to what is called grid supply points, from which customers are, from which essentially distribution companies take power from the transmission facilities. And the major distinction, I think we mentioned yesterday, between transmission and distribution is that transmission is done at very high voltages, which in Nigeria is defined as 132 megawatts, sorry, 132 kilowatts, kilovolts, sorry, kV, 132 kilovolts and above. For that, if you're transmitting or moving that level of power, then you need a license, a transmission license, and the two voltages that typically, the two very high voltages that we operate at in Nigeria, 132 and 330. Then distribution is the act of taking power from the transmission, the grid supply points on the transmission network through to the customers' homes, facilities, factories, etc. Distribution is typically done at 66 kV in a few areas. The more usual distribution voltages are 33 and 11 kV. Again, the Act says that if you're not distributing more than 200 kilowatts in a location, then you don't need a license. I'm struggling with what that means, but the one exception that I think will clearly come within that is that if, for example, you set up a mini grid to supply, say, a few houses in the village, the generation is probably around 50 to 60 kilowatts. You're distributing within the village. Then by the Act, you clearly do not need a license. And I do know that NEC has issued mini grid regulations and likes to have a say as to what's happening in that space. My view is that the NEC should leave that and focus on trying to get us to a market that works. The other activity for which a license is required is the act of trading. So both transmission and distribution are, strictly speaking, wires businesses. Is the business of providing, the analogy I used yesterday was a road, the channel or medium over which power is used. So for TCN, for example, that's all it's meant to do, move the power at high voltages. Discos are also move power, but they have a second side to their business, which is selling the power and collecting money for the sales. But a power trader does not have the wires. All it does is enter into contracts for power to purchase power and to sell the power, and then also into contracts potentially with parties to move the power for it. So MBET, for example, is a trader. All it does is buy power from generating companies and sell to distribution companies with the power moved over TCN's wires. The plan is for when the industry gets to a higher level of maturity for there to be companies that actually all they're doing is trading. They're buying power from a generator or from our distribution company and reselling to us as customers over the network of existing discos. A little bit further down, when we're talking through the issues, we might talk as to whether or not we're at that point. So to go back to the licensing process now, the first thing that happens is that the applicant decides that he needs a license, right? And so he submits an application. That's that first oval that we have in there. How do you do that? You go to the NEC website and download the application form, complete it and submit it to NEC, pay the application fee, which is varied depending on what license you're applying for. What used to happen in the fact is that NEC then reviews the application to determine whether it's complete. That's that rectangle, the first rectangle to the right at the second level. NEC then has a decision to make at that point. In the past, what will happen is that NEC will determine that the application is complete, and then it will acknowledge if it's not complete, it notifies that it's not complete, and you have to go back and provide the completed information and the correct information. If, however, the information is complete, what NEC used to then do at that point is to say, okay, you can now publish the fact that you are applying for this license in this location in 2 newspapers. There are 2 publications that are required by the regulations. One is in a paper circulating nationally. Another is in a paper circulating in the in the locality where the operations will be performed. What NEC has moved to, I think, over the past, I'd say 2 years, year and a half, is to actually, once he receives the application, even whilst going through his review, to confirm completeness or otherwise, order you to publish, right? So what NEC would, so really I shouldn't have this rectangle that's colored lemon, probably should have the same color with everything else, because once you submit, NEC then orders publication and then starts its review. If the review, if the application is then incomplete, it will then ask you to, even after you've published, to provide the additional information that's required. What happens after publication is that the whole world, including parties or that are operating in the area that you want a license, or residents or whatever, that feel that that license should not be granted, will come up to you and say, I will come to NEC and say, no, I object to this license being granted for A, B, C, D, E reasons. So there are two such objections that I think are typical, right? So there's a client of mine once that applied for a license in one of the free trade zones. And so we then got an objection from another party that says, oh, this is a free zone and NEC has no business licensing for operations in the free zone. That's one. And two, that by the way, we have an agreement with the free zone to provide all the power in that area. We went back and forth. Ultimately, the matter was resolved. So what NEC then does is that it then holds a hearing between the parties to determine that objection. Typically, you're required to publish for 30 days. The party that seeks to object must object within 30 days. And I think within another 30 days, NEC should schedule a hearing. In that case, NEC decided that NEC's decision was that it still has the power to issue licenses, and even that company that had an agreement with the Free Zone Authority should apply for a license. And that, and we'll come to this in a minute, that the fact of one party being licensed to perform an activity in an area does not necessarily mean that it's got exclusive rights to do that activity. So the other usual objection that you will see is where a party applies to be issued an IEDN license. IEDN, we said, is an independent electricity distribution network. So NEC has the IEDN regulations, which provide for rural IDNs, typically for a place in which there's no current, the incumbent disco does not have any facilities, as well as what's called urban IEDNs. I mean, say for example, within Lagos, there's nowhere in Lagos that there's no coverage. Although I do notice that Lagos State has a policy document that's going through consultation now, where there's an argument that coverage does not mean that there are the distribution facilities. What it should mean is that there are facilities, and the facilities provide all the power that's required. So what the NEC IEDN regulation says that even in an urban area where there is disco coverage, if you can establish that the supply that the disco is providing is sufficient to meet all the requirements, then you can make a case for an urban IEDN to be licensed. What we're seeing, however, is that typically these days, when you apply for an IEDN in any area within a disco, what typically will happen is that the disco will immediately object. And I'd say over the past 2 years, it's been extremely difficult for NEC, for whatever the reason is, to issue those licenses. We talked yesterday about the need to protect the disco's franchises from cannibalization. It does appear to me that without clarifying its position and the conditions for departing from the, I'm putting it in quotes, the assumed monopoly of discos, NEC is also being very careful to not be in a place where its actions are deemed to make the discos even less viable. So for example, there's a suit, I believe, involving NEC and the company that applied for an IEDN within its within the franchise area or BDC. BDC has sued NEC as to the propriety or otherwise of that license. But anyways, what I've seen over the past 2 years is that the question as to what a DISCO has monopoly of and what the DISCO can do or not do has been one that has tasked NEC and has made the process of approving IEDN license applications very difficult. But anyways, if there's no objection or if there's an objection and it's decided in favor of the applicant and NEC has reviewed everything else, determined that everything is in order, then we'll come to that diamond at the bottom. So once NEC has completed the review, including any objection process, we'll come to the diamond at the bottom. If the view is that the application is appropriate, we go right. If it's not appropriate, and I'll tell you what the reasons might be, we'll go left. There are 3 things that NEC seeks in a license application. The first one will be, and I think we spoke briefly about it yesterday, financial, technical, and legal. I'll start with the legal, which is the easiest. Is this entity properly set up? NEC requires it to be, although the Act doesn't say so, but NEC requires a limited liability company. A licensee must be a limited liability company, so there must be proper setup and there must be proper approvals from the corporate bodies for the application. Financial, we want to see that the project is viable and that the company has the ability to finance it. Typically, NEC will require a letter of sorts from the bankers or proposed financiers for the business. Update, it also reviews the balance sheet of the applicant to be sure that it does have the resources to carry the equity that the project will review, that the project will require. Our view is that that's a wrong approach to take, because I might be promoting a $1 billion project without having the balance sheet to carry that. But if I know how to arrange the financing, there shouldn't be a reason for me to show up with all the equity on day one. But anyways, NEC wants to see that the party can finance the project and that the project is commercially viable. Technical, we want to be sure that the technology proposed is right, it's approved for use in Nigeria, and that there are things like, if it's a grid connected project, TCN has indicated that yes, it can move the power generated under this project. So if NEC finds that the application is appropriate, it issues a notice of, it notifies the applicant that it's been approved, asks it to pay the licensing fees, and then issues the license. However, if it feels no, that license is not appropriate, then what it should do is notify that the license is rejected, and the the applicant has a right to appeal NEC's decision to reject a license. I'm not aware of any appeal in that regard. It might be that there are some that I haven't come across. By NEC's regulations, this entire process should take no more than 6 months. It's very often the case that we see it take a bit longer. I'll just talk through a few issues on the key licensing areas, on some of the issues that we're seeing. I apologize for the typo on that slide. We'll correct it before circulating it. So for on-grid generation, right, what NEC is saying now is that and that's on-grid is first, whether it's you are connected to the TCN grid or you are embedding within a DISCO grid. Once it's a power plant to be connected to the national grid with a view to supplying customers that are captive to the DISCO, then NEC wants to see competitive procurement. We spoke quite a bit about that yesterday, and wants to see that there have been studies by the system operator showing that the power is required. Also, NEC wants to see compliance with its power procurement regulations, which really it's those regulations that speak to competitive procurement and studies we have spoken about. The critical issue, like we said yesterday, however, is that because there's so much extra generation on the grid, it does appear to me that there isn't a lot of appetite by the regulator or even by NBET or discos to procure additional power generation for our grid. For generation that's off-grid, i.e. not connected to the power grid. So an example would be, say, for example, you have a facility, a manufacturing facility that requires, say, 2-3 megawatts of supply. It's then approach the power producer to come and install gas power generation sets on site in return for PPA tariffs, right? That's not connected to the grid at all, right? And so the power procurement regulations should not, the bulk power procurement regulations should not apply to that customer. What NEC wants to see in that case is to be sure that you are not going to be trying to distribute power without a distribution license. I've already spoken to the challenges with getting NEC to issue IADN licenses. And so what's going to happen is that what we find in that case is if there is any distance between where the power plant will be and where the customer is, that project becomes difficult to approve, because then you'll be, I mean, remember that the threshold typically that NEC wants to see is 2 megawatts because it's completing that with the eligibility requirements. And once it says that, okay, there's no eligibility here, then, and the limit for distribution without a license is 200 kilowatts. So by nature, that project will be more than 200 kilowatts, right? And so you've got to be within the fence, so to speak, for it to work. I've seen situations where, so the customer is within the fence, all of a sudden somebody shows up about 300 meters away, and we're saying, okay, can I sell to that party as well? Can we just draw a little line to provide the supply down the road? Again, in the two instances where I've seen that come up, it's been difficult. Really, it's been impossible to get NEC approval. The two issues in there is that how does this project impact the incumbent disco in the area, and whether or not a competition transition charge will be paid. So the way we spoke yesterday that typically distribution companies the way we built up our distribution tariff is that the industrial users subsidize other users. They are cheaper to supply, but they pay more. So if you take a big industrial user, so I know in Disco, for example, there were 40% of its collections in one state come from one customer, a steel factory. So imagine if the Disco were to use that factory, all of a sudden, all of its operations in that state become not profitable. Also, I go to that customer and say, you know what, I'm going to put up a power plant for you. Disco is charging you 55 naira. I can get you all in. I can get your costs to be at 50 naira. At about 30, 40 megawatts of supply. That's a massive saving to that customer, right? And there's no way it's not going to be attractive. It's not going to find that proposal attractive. So next says, hey, hang on, not so fast. If you pull out this customer from this Disco, really, the Disco becomes not viable. So my experience is that it's extremely difficult to see those kind of projects licensed. And then what the law actually provides that in that case, what should be paid is what's called a competition transition charge, which is meant to compensate a Disco for customers that it loses as a result of the evolution of the market towards more competition. There are a number of factors that have been compensated for. It's been compensated for the investment, made to deliver power to that customer. So maybe there are special transformers, there are special lines built to supply that customer. That's one. It's also been compensated, so to speak, because of the way we designed our sector, for the loss, the hole that's created in its in its revenue requirements by reason of that customer not being there, i.e., it's been compensated for the cost, for the cross subsidy that is lost. So for all these reasons, it's not so straightforward a matter as, oh, I'll build a power plant and I'll supply the customer. There's a need to understand the impact on the rest of the discos operations and what will happen. The other point for IEDN licensing is whether or not the discos have a monopoly. I mentioned earlier that there's a provision, and I think I'll pull it up on the next slide, which is that unless it's expressly stated in the license, no licensee should claim that it has exclusivity in its area of operation, although it does give power to NERC to grant exclusivity as regards any license. As far as I know, there's no party in Nigeria whose license states that it's exclusive for that purpose. So whether it be TCN or any other party or any other disco, nobody can claim exclusivity. But the experience that we've had has been that NERC this one, can you mute please? Thank you. So the experience that we've had is that there appears to be the discos assert a monopoly. The argument they make is that the basis on which they were licensed was that they will have exclusivity in their areas. Now that principle, in my view, there are many arguments that can be had against it. One is the fact that nothing in the license says so. Act is actually quite clear as to the fact that a licensee cannot claim exclusivity. And three, the IEDN regulations are also clear that NERC will issue an IEDN where the disco is unable to satisfy all the requirements. And we can also extend the argument to say that the intent and the spirit of Nigeria's consumer protection and competition law is to promote competition, even though it does give the FCCP a requirement to consult with the discos with the industry regulator if there is a need for a monopoly of sorts in a particular industry. But monopoly is not something that can be assumed, and discos should not ordinarily assert a monopoly that flies in the face of law that exists. Having said that, there is a valid and genuine argument to be had against protecting a monopoly or franchise of sorts for distribution companies in order for them to remain viable and profitable to deliver a supply to everyone else. Otherwise, what happens is that everyone that can pay more than the normal tariff goes off the grid, and then the grid is unable to sustain the operations that need to happen on it. Transmission. Today, the only party licensed to do transmission is TCN. We spoke yesterday about not doing a consultation for an IETN for independent transmission networks. As far as I know, none has been applied for, none has been granted. I was actually part of conversations recently though, when NEC indicated that it will be willing to grant independent licensing for a particular transmission path. Given that the TCN today is both TSP, transmission service provider, and system operator though, it will be interesting to see how TCN reacts to such a regulatory initiative and how the system operator, so to speak, coordinates the independent transmission network with the TCN's network. For trading, you'll see that I have, what's going on here? We've actually fielded a number of inquiries in which investors are asking that, okay, why can't I come in as a trader and buy power from one party and selling to the other party? The problem is that ultimately, to trade power in Nigeria, you're going to have to move the power over a network. TCN is probably as near, and so that requires open access networks. TCN is as near open access as there is. I'm sure if you're required to sell power in Nigeria, to move power over TCN's network, TCN probably will once it gets paid its transition use of systems charge, it's probably happy and fine. And we'll talk about all the TOSs a little down the line when we're talking about industrial agreements. It's fine to move your power. But most customers that you see are connected to a distribution network, and it's extremely unlikely that today a disco will allow you to move power over its network because it wants to keep the same customer and to sell the power. Maybe down the line, as we evolve towards more competition, the distribution activity, the sale and supply activity will be separated from the sale activity in distribution. And then the distribution simply becomes a wires business that's required to operate on open access principles. At that point, the conversation can be had as to whether or not we can have when trading licenses might then become more usual and typical in the industry. But today, the only trading license we have is the special trading license issued to NDP to embed, which enables you to buy power from the generating companies and resell to the distribution companies for the reasons that we spoke to yesterday. I think we should take questions on licensing now before we go on to the key transaction documents. So maybe please, do we have any questions from the audience?
Oh yes, Shola, thank you very much for the expose. We have a question here from Chairman Okolose. He makes the point that it is not the regulation, the point that it's not the regulator's job to protect the consumer is highly problematic. The regulator is part of government. Even though it's independent of the executive, the regulator serves the people and has been appointed to ensure that not only is there fair competition between commercial actors, but also that there's responsible business conduct that does no harm to the people. The idea that the regulator is not responsible for protecting the people is part of the reason governance in Nigeria is disconnected from serving the people.
Okay, so the first point I'll make is that the regulator is not government. It's a difficult concept for many of us. I remember having an argument with a very senior lawyer that, in my view, is quite knowledgeable and is someone that I have quite a bit of respect for, that couldn't grapple with the fact that the regulator is not government. You have governments that you elect into office to protect consumers' interests. You have the Federal Consumer Protection Commission to protect, although it now managed to jumble consumer protection and competition into the same commission, to protect consumer interests. Any economic regulator, any regulator of any sector is not there to protect consumers. Once we conflate consumer protection and regulation, we create a problem for ourselves. The job of the regulator is to balance all the competing interests. And the truth is that the interest of the consumer and the interest of the operator are always going to be headed in different directions. The consumer and government are aligned in that they want the best supply. They want the best supply at the least possible cost, right? The regulators, the operator's interest is to sell as much power as possible for the highest returns it can get. The regulator's interest is to come in and say, hey, hang on there. Yes, we must get a supply, but the man making an investment must also recover his investment and make a reasonable return. They can't make what I call armed robbery returns, but it's got to make returns that are reasonable and are usual in this case. Part of the reason why we accept a monopoly of sorts in a wires business is that there's a regulator that controls how much of the return that wires business makes. But the regulator is not your protector. Because if that were the case, then the operator has a problem, right? The party that has the power to, so to speak, license the regulator and the operator, determine how it operates, is acting for a party whose requirements are diametrically opposed, whose desires are diametrically opposed to the operator's requirements. It's the same way when you and the party are in court. The court's position is to apply the law, not necessarily act for one party against the other. The regulator is not for protecting the public. Is to ensure that economic, and there's a point that we make, I think, at the very end of the presentation that I'll go to. Oh, sorry, excuse me. So the regulator's position, is essentially, to ensure a balance of interests, right? Is to ensure there's universal service at minimum cost. That's not protecting you and I, it's ensuring that the industry works. So that's how I'll answer that question.
Thank you. The next comment is from Adamu, forgive me. Captive generation is for self-generation and consumption, true?
Yeah, thank you. So yes, the way captive generation is defined in the Act is generation for the generator's own use, which is not sold to a third party. So that's how the Act defines captive generation, and the Act expressly says that that action does not require a license. It's important to differentiate the concept of captive generation from captive customers, which are customers that have no choice but to buy power from the incumbent disco. For example, if I'm living in one house down my street, it's unlikely that I can engage someone to come and build a power plant to supply me. I'm a captive customer. But captive generation is generation that is used by a party for its own use. So yes, the answer to the question is yes.
Right. Chairman says, thank you, Shola, for taking my question. Leonard Silgodi Uche says, big kudos to the organizers. Femi Fajolu's question says, what can be done to ensure regular electricity in Nigeria? There has been too much grammar concerning this subject matter, and yet there is no light to use.
Thanks to my friend Femi for that difficult question. If I knew the answer, I won't be here talking to you now. I'll be here chopping all the money from that. But you're right. There's been too much talk and too little listening. My view is that that's the kernel that's the biggest problem in the sector, right? Everyone has been busy casting blames at the other party. There's need for more coordination between all the parties, understanding what the disclosed issue is, what the generator's issue is, the regulator acting as a properly impartial. There's a part of my answer that I should have given to Chairman on the regulator's powers, right? The real issue is that government does not want people to pay too much because government thinks that that's unpopular and it might cost it votes. If government wants to protect people, what it should then do is write a check to cover the subsidy. The truth is that no government anywhere in the world, even much richer governments, can subsidize power. It's likely to bankrupt the government, right? We see what oil subsidies doing to us, petrol subsidies, power will do even worse. So you need to allow operators charge a tariff that works, but then the regulator also has to be strong and hold them accountable, right? So that whatever their issues are, they need to essentially deliver on their universal service obligation. And if they don't, then you have a basis for saying, okay, I'm going to move away from your monopoly and allow any other operator to come in there and deliver the power. Once we're doing that, we're building the market in a manner that ensures that everybody gets supply. And maybe, yes, nobody can do it in 5 years, but probably 10 years from now, we're operating in a sector where nearly everybody has all the supply that it needs. Mabel?
Yeah, thank you. I was just thinking out aloud. What would be your best form for financing for this people to ensure that we get it right within this sector?
Financing for the sector.
Yes.
So one of the interesting things that we're seeing recently, right, between pension funds, between the kind of returns that capital can earn outside Nigeria, in some places now it's gone negative, which means people are charging you for saving your money. So even all of the initiatives that the CBN is undertaking to compel commercial banks, right, to pull capital for investment, is that I do believe that we have much more than sufficient capital to make the sector work. It's not about capital, it's about building projects that are sufficiently, that are structured in a sufficiently robust manner, that all the risks, and we'll talk to some of them when we're talking about transaction documentation, are addressed and appropriately either mitigated or allocated. Once that's done, then the capital to make the projects happen will show up. We're beginning to see a little bit of activity in that direction. I am aware of a company that has raised several hundreds of millions of dollars to do power projects, because those projects are properly structured. They're structured in a manner, one, to ensure that the key risks that we're seeing in our sector are addressed and mitigated, and the money comes back. And the singular biggest risk is liquidity, i.e., the party collecting money from the market, the disco, is not getting enough money in to pay for the cost of the entire value chain, as we spoke about yesterday. So I think capital is not the issue. If we've done everything we should do about regulation, about structuring our industry, then all the capital required to fund the works that are required will show up. But some of the most intelligent, parts of any industry is the financing. The financing looks at your sector. If you don't answer all the questions about the risk, then it's not going to come.
Thank you. Let me just quickly take Gabriel's question. By the way, Ejima Hata Oriari says, thank you for your responses. Gabriel says, my question is similar to that of Okose above. If the facilitator says the regulator is not expected to protect consumer, why does most regulators enabling law focus on consumer protection, and even FCCPC recognizes the role of sector-specific regulator and role in consumer protection?
So the regulator's most important role is to balance interests between the investor on the one hand, and the government and the consumer on the other. The protection that the regulator gives you is that if, for example, your disco is the only place you can get power, it will protect you from price gouging by setting the tariff. It will protect you from unfair billing that doesn't follow the rules, right? But that's not necessarily an activist protection. It's a protection that's inherent in its duty to balance the interest of the public, right, and the investor. Until we understand that NEC is not on our side and should not be on our side. So to partly answer Femi's point as to how do we get it right? One of the singular biggest hindrances for serious operators coming into our sector is not being sure that government will recognize the regulator's independence, and that the regulator can stand his ground to say, no, we can't do this because it's not in the interest of investment in the sector. So we can't look at the regulator as a protector of the consumer. Its work is to balance the consumer and the investor's interest, right? It's in the investor's interest it's in everybody's interest, the entire system's interest, that investors operate in accordance with their licenses and follow the rules. If an operator is in breach of the rules, yes, it should be sanctioned by the regulator in accordance with the laid down rules, because that's what we've agreed to. But it's also important for us not to see the regulator as being on our side. The regulator is independent. It should not be on anybody's side. The moment when I was talking through this slide, I said the most important role of the regulator is independence. The moment it takes any side, right, with any of the parties, then that sector will not work. And the Nigerian power sector will struggle until government, the regulator itself, and consumers understand that the regulator is just that. It regulates and balances the interests of all the parties. If any consumer is of the opinion that the regulator hasn't been fair in the way it's applied the rules, the courts are open to the consumer. Government is probably there to protect us, and there are aspects of consumer protection that you can take either to the industry regulator or to the FCCP as the consumer protection body, but the regulator must be impartial. Part of that impartiality is requiring operators to comply with the rules, and some of those rules include not engaging in practices that are unfair to a customer that's captive, for example. But we all need to understand the fundamental principle that the regulator must be independent of us consumers and independent of the government.
Thank you. And Chris Annie says, is there any measure that this regime has helped our power supply?
Please, can you repeat that? I didn't quite hear that.
Is there any measure that this regime has helped our power supply?
I'm not quite sure I understand the question, and I typically do not speak to regimes. I speak to data, right? And so the simple way to answer that would be to go to tcn.org and look through what average generation and delivery was over the past, say, 2 or 3 years. You can then make a decision as to that yourself. But generally, we've been trending upwards very slowly, I think slower than can be, for the main reason that people have been too busy fighting and pointing fingers as to where the blame should lie. I'm seeing some initiatives now towards trying to address those issues, and if those initiatives work, the system should improve. But the solution to the problems is not government alone. It's government, it's a regulator, it's also consumers. Labor needs to get off fighting every time there's a tariff increase. But in terms of plotting the graph as to whether power supply has grown or gone down, which is the only objective criteria that you can apply in answering that question, I'll say you could just do a comparison of data. It's freely available at tcn.org.
Thank you. David says, what is the best approach to issues of overbidding by a consumer without prepaid meter having complaints severally to the relevant bodies? Is court, or are there better alternatives?
Report to NERC. You might or might not get relief. There are all kinds of rules that NERC has about capping estimated billing and compelling meters. And potentially, yes, if you don't get relief from NERC, you can go to the courts. Unfortunately, I don't believe the discos have done well enough in that area, and I also don't believe NERC has done enough about even enforcing the laws that it has put in place. But ultimately, it's a critical matter. And now back to NEC exercising its consumer protection. It's enforcement of the rules powers, right? It's already come out that say that if there are no meters, then estimated billing is capped at so much. It's also put on every operator an obligation to meter everyone, and there is financing now, so to speak, for them to get the metering. So there really shouldn't be any excuse for a customer not being metered. And yes, there's relief before next consumer. The name escapes me, but NECA does have an avenue for making complaints like that. And two, also, if that fails, you can go to court against both NEC and the DISCO itself.
Thank you. This is coming from Raymond. He says, with recent moves by the Lagos state government to start its own electricity market, there will be a need to establish a regulator when the plan goes through. How do you suppose such a regulator will coexist with NERC in terms of granting licenses and exercising oversight over stakeholders like DISCOs, like the coal distribution and Ikeja distribution company?
Thank you, Mabel. Please, I'll take the question now, but I think let's limit the additional questions to 2. And then when we do wrap up, we'll try and see how many more we can take at the end of the session. I'm also going to, please, after the questioning, I'm going to ask for a 2 to 3 minute break, please. And
that's
then
fine.
we'll go, please. So, interesting question from David, especially as to the consultation that I'm aware Lagos State is undergoing. With a view, it says, to establish a separate power market for Lagos and to establish a system operator and also a regulator for that market. Those moves raise, in my view, fundamental constitutional questions around what's the exclusive precept of the federal government and what's concurrent. On that, I think is items 13 and 14 of the constitution of the concurrent list in the constitution. The views that I have are that the positions advanced by Lagos in that consultation paper might be a bit extreme, but I'm also saying this without the benefit of having done a proper deep dive into that consultation paper. Yes, the constitution empowers each state to, so to speak, establish bodies for the maintenance and supervision of power plants and distribution facilities within the states. It does give the states certain powers, but I think that it's important for that there is a careful analysis between so let's back down a bit. About 4 or 5 years ago, Light Up Lagos was raising quite a bit of buzz in the market. A lot of people were talking about Lagos State's ambition to cause the generation of 3,000 megawatts for Lagos, whether it's Lagos State or Lagos as a city. The plans, unfortunately, didn't go very far because we didn't generate a single megawatt under the plan. I'm not aware that any single distribution line was built, right? My view, right, is that yes, policy is important. Laws are important, but under the current laws that regulate the sector, there is a lot for whether it be state governments or private parties to collaborate on to make things work. If Lagos' objective is for us to be moving all the power that we need to move in Lagos State, including up to 3,000 megawatts, if the territory of Lagos can take it, I think there's enough under the current law and under the current bodies that exist to do that. And I'm always extremely careful about there are many parts of our law that needs amendment. There are many parts of current policy and regulations that can be upgraded or updated. But I'm not quite sure that a power market solely for Lagos, a regulator solely for Lagos, gets us to all the power that we need in Lagos. I'm not sure there's much more I can say to answer that question than that. Mabel?
Yes. There's this question from Polari. It says, if captive generation requires a permit and not a license in certain instances, if the generator wants to distribute its generated power, why will such generation require an IEDM license instead of a permit? This seems to be a position of the regulator.
Thank you. So first of all, we're departing from the premise that my view is that the requirement for a captive generation permit for a party for its own purposes is ultra wireless NEC. That's my. But let's hold that for a minute. So what NEC says is that if you hold a captive generation permit and you want to sell that power to a third party, then you must get yourself a generation license. Because NEC agrees the act is quite clear, you need a license to generate power for sale to third parties. That's the first bit of that. The second leg, however, remember that we said the APSR Act is quite clear. Once you're moving power that's more than 200 kilowatts, then you need a distribution license. So that's why NEC will say if you are moving the power for sale to a third party, you will need an IEDN license. Remember?
Thank you. Adeyemo saying, so where do consumers go for respite? It's like being between the devil and the deep blue sea.
Maybe I've been a bit too, maybe I haven't been clear enough in what I've said. Please, there are disputes or adjudicatory panels, there are fora that NEC has for consumers to come for respite. But it's respite when the operator is not following the rules as laid down, right? So the regulator protects you from the DISCO acting in an unfair and illegal manner or against the rules. But the regulator is not on your side. His duty is to balance your interests and the operator's interests. Balancing those interests require the operator, who remember is in many cases a de facto monopoly, to act in a certain manner. And the rules around those are clear. If it's not observing those rules, then you can report to the regulator. You can ask the regulator to take certain actions. The regulator will hear the other side as well and come to a decision. The same way when you report your neighbor to the police and the neighbor gets charged, neither the police nor the courts are protecting, they're not on either party's side, right? At least that's the theory of the matter, right? So I'm saying the regulator's job is not to protect us as consumers. Its job is to balance every party's interest. But that balancing of interest requires that everybody, particularly the operators, follow the rules as they are laid down. That's how, and I'm hoping that I've addressed that clearly, but if not, please, I'm happy to take additional questions on that particular point at the end of this of the session. But please, it's extremely important that the regulator is impartial, is not on any party's side. There was a certain NEC that many people feel created problems simply because the regulator took the view that its view is to protect the consuming public against the operators. That's a quick way to create even more problems than we have. So I'm going to go into the next session, but please, I would ask for a 2-3 minute break. It's 30 minutes past 4 now, so I think we can restart say by 4:16 in 3 minutes, please. Thank you. Thank you, everyone, and welcome back. We're going to talk through over the next 20 minutes or so key transaction issues and documents. Because in both cases, right, a lot of what we'll see being developed are generation projects, right? Yes, I'm sure a number of us will also see what I'll call IDN developments. The session is it's almost aimed at IPP development issues, right? And so what you find is that many of the agreements that we speak to address a power generation project being developed. I do know that I'm speaking in the context of having said that our problem is not more generation, but you'll find that still most of the projects that you'll be called upon to advise on would involve some element at least of a power plant being developed or power being sold from a power plant, which is why the document that we speak to mostly is the power purchase agreement with which power is sold. And by the way, even if some of the initiatives that we're seeing now materialize, then it might be the case that 3 years from now, we'll see a whole lot more activity in grid-connected power projects. And I'd like to open the segment by talking through some of the key development issues in developing a power project, right? And essentially, the main, I would say, work to be done is to look at the development process, understand the risks, and then find a way to either mitigate the risks so that they become not as important, or at least they're allocated to the party that's better able to absorb the risk. And remember when we were talking about industry key players yesterday and where the industry starts from, we started from the gas producer, the upstream company, right? And so also in developing an IPP, that's an independent power project, the first, so to speak, you start from also the fuel supply. I'm addressing gas supply because again, most of our power generation is thermal or gas-based. You might find the issues will be somewhat similar, although with a different color. If you will say, for example, an hydro project or a solar project, you still need to be sure for hydro that the water rights exist, and there's probably a conversation to be had with the Federal Ministry of Water Resources as to the rights to whatever river that is being dammed for the power supply. For solar, the issues are somewhat less. You're essentially trying to be sure that you've done the studies to be sure that there's sufficient. I use the word sunshine. The technical term escapes me. That you're sure that you can you have enough of that at the site, and then it's a function of just ensuring that your client has proper title to the site. But for thermal projects, which is what for gas projects, which is what we're focusing on, essentially what you're looking at is to be sure that there's a supplier that has sufficient gas reserves and that is going to sell gas of the quality that are agreed into the project. Historically, we used to see the requirements as on the one hand, you're trying to secure enough gas to generate the power you want to generate. But because of the issues we are, and so that requires a take or pay obligation to say, I'm going to buy so many millions of gas a day to operate my facility. Because of the liquidity challenges that we've seen in the sector, however, generators are not able to even sell. You remember I said, look, we've got 13,000 megawatts installed on the grid. But if you're not being dispatched and you're not generating, that means you're not taking gas. But if you have a take or pay on the gas, you have to keep paying for that gas. So some of the contracts we're seeing now are actually not take or pay. It's simply if you take the gas, you pay for it. But the traditional way in which gas supply contracts into power have worked is to require you agree the gas quantity, agree the quality of the gas to show that it's properly processed, and agree where it's delivered. Once it's then delivered, you go into the process of transporting the gas. You're talking about the pressure at which it's transported and delivered. You're making provisions to ensure that it's always available, and also as regards the quality. But in any case, once gas is then delivered to the facility, once you've secured a supply of gas, remember that this process starts and this contracting starts whilst you're developing the project. You then look at what the IPP requires. Again, what are the key risks that you have to address? The biggest and first risk at the point of, okay, let me go back a bit. Most power projects, most IPP developments, right, are the typical project finance and development and finance, which means you have to, the developer has to essentially put together a suite of contracts that form its principal asset, which is what it then raises the financing to do the project with. So at the time you start doing the documentation, at that point you haven't built the plant, right? So on the one hand, you're telling the party that will buy the power from you to say, okay, I'm going to build a plant in this location. Because if we're working in a system that's right, the buyer will have planned that, okay, I'm going to need X megawatts in that location in 6 months' time, or sorry, in 3 years' time. So by the time he's signing that PPA with you, it better be sure it will have planned it into, it will have put it will have scheduled its requirements in a way to expect that that plant will come up in that time. And if the plant doesn't come up, then it has a problem. Meanwhile, you are developing the project, there's all kinds of risks as to how you deliver it, including the fact that there might be issues with your contractor. So it's important that the construction risk is properly allocated, and what you typically will see is a requirement for liquidated damages if the plant is not built. There's the O&M risk, and the idea is that, look, beyond building the plant, you also want to be sure that, particularly for a developer that's a financial rather than a technical investor, you want to be sure that you have the proper partners that can do or that can operate and maintain the plant. I think in the case of Azura, for example, the original promoters or the sponsors were not technical. Although if I recollect correctly, they ultimately had partner investors that also were technical. But you have to be sure that you also choose the right technology. Very often you hear a debate in industry as to whether one turbine manufacturer's equipment is better or not, and the debate typically centers around whether or not there's enough knowledge and experience in country to service the technology. There are all kinds of issues around having spare parts to ensure the plant continues to operate, to ensure that also that the plant is properly financed. Because again, remember that the IPP is being built with a view to earning revenues over the lifetime of the PPA. So if your financing rate is too high and the PPA tariffs don't cover it, then the developer ultimately might have a failed project. That gets us to what I'll call the offtake risk. Up until now, what we found, what existed in the Nigerian power sector was that the main, or should I say the only, let me be careful, the main offtaker was NBET, because that's how we designed, that's how the industry evolved, right? And once MBET was not able to pay, then there were liquidity issues that affected everyone. So imagine, for example, if an IPP developer had built his power plant off the back of a PPA with MBET that wasn't properly secured, and then MBET is only able to pay 20% of its PPA receipts, its PPA obligations, which is what was happening, right? You borrowed money. The typical financing split will be, in some cases, 25 equity, 75 debt. Although I think in some cases you'll see 20, 80. On the average, you might see 30, or you might see 30, 70. So if you've got financing on the back of 70% of your financing, and the buyer is paying only 20, 25% of PPA tariffs, what that means is that you don't even get enough money to cover your operational maintenance to remain in business, talk less of being able to service debt. Luckily, I would say, and good for them, the only the main project financed IPP in Nigeria, Azura, got payment security that was robust. It got a World Bank backed PRG, partial risk guarantee, that ensured that non-payment by NBET will not, so to speak, bankruptcy, because the risk of that guarantee getting called means that NBET typically does everything it can to pay Azura, whilst other generators might not be paid the rest of their PPA tariffs. But again, also, the party that's procuring the power, as we said a bit earlier, has to be aware of and to look to mitigate. So if you're on the buyer side, you also have to look at provisions to protect your client against the risk that the generator, the IPP, does not perform. We come to transmission, right? All are agreed. I think there are only a few plants in Nigeria that are more than 50 megawatts and are not on the TCN grid. So virtually all the generation that goes to the discos, in fact, I'm tempted to say all, come through the transmission risk, right? So again, the risk exists. And this is one that we see all the time, right? Every once in a while, the entire system collapses. That means no power can be delivered. So the risk exists, one, that evacuation, right? That the facilities, that TCN builds the facilities to evacuate power from the power plant and put it on the grid. In fact, what we've seen in many places or many projects, I know of at least two, is that although it should be the duty of TCN to build the evacuation from the power plants to where the grid currently exists, very often the power plant developer does that last mile. And then you also then start trying to ensure that TCN operates its facilities in a manner that's reliable. In many cases, what we've seen, right, is that unfortunately, TCN is a monopoly that acts like a monopoly. In fact, there are times that you see TCN acting as if it were a quasi-regulator. And we find that whether its system collapses or other failures, including even line losses on the TCN grid, is paid for by other participants in the industry, typically by the discos, which means you and I, the customers, are paying for it. But again, that's a risk that everyone needs to be aware of. And also, the same way that the discos are not paying enough to pay generation, the transmission systems operator too also has to, or the TSP has to figure out ways to, excuse me, mitigate the risk of discos not paying the transmission charges that are due. On the distribution side, of course, again, there's a need to operate and maintain the disco network appropriately. We spoke yesterday about part of the reason why the system is not working well is that the investment required is not going into the distribution network. Everybody knows that there are metering challenges, and so it's possible that, in fact, it's likely the case. So when you look at the what's called the ATC and C, the aggregate technical collection, commercial and collection losses, right? i.e., when you look at how much power is delivered to the discos and how much power they collect for. In some discos, the number is higher than 40% today. So when you have a system that for really lack of sufficient investment, you're losing 40% of what comes in to be sold, it's clear that there's going to be a challenge all the way down the chain to the man that's selling gas into the system and the IPP developer itself. So it's important to understand and try and figure out how to address all those risks. It's in fact, in my view, and I think this is a view in which there is near universal acceptance. The reason why the Nigerian power sector is not particularly attractive for investment today is that we haven't addressed this disco risk. And that's why, for example, to build a new IPP is difficult. That's why we have almost 8,000 megawatts of storage capacity on our grid. That's why it's difficult to privatize successfully any generating power plants on the Nigerian grid today. And a large part of that is the risks that you see highlighted at the bottom of the column on the right. Essentially, it's important that regulation is done in a manner that's not protective of any party, whether it be consumer or the operator, but done in a manner that's fair, and that tariffs are allowed to move in the direction that they should move. So what I've tried to do on this slide is to talk through the range of risks that exist across the different subsectors of the industry, right? In a manner that looks at it from the perspective of whether it's the operator in distribution or transmission, but that critically an IPP developer coming to the market needs to understand that it's not just your IPP specific risks, there are wider sector issues that might impact the viability or otherwise of the IPP. In the next slide, we'll talk to what I'll say are specific IPP specific risks that we should be aware of when we are documenting or advising on an IPP development. The first one is, of course, expropriation. Yes, we're all aware of Nigerian law that says that in the NIPC Act, right, investments, government will expropriate it, but that's always a risk, right? State governments always have the power to revoke land, for example, for a public purpose, and that's something that might impact investments in assets. So it's important to understand that risk and to allocate or mitigate it in a manner that's best. Now, my view, it might not be an unpopular view, but it's the only view in my view. So it might not be a popular view, but it's the only way to think about these things, right? The only reason somebody builds a power plant is to sell the power to the market. The only people that buy power in the market are consumers, you and I in our homes, you and I in our businesses, factories and industries at their facilities, right? So every power plant that's being built is built for consumers. So ultimately, the parties, where the risk, we have to find a way to transfer the risk to the market. Otherwise, we can't get private capital to come and develop it. But also, it now should mean that nobody can just indiscriminately say that I want to build a power plant, I'm going to push the risk on the market. No. That's why the principle and the ideas behind next bulk power procurement regulations are actually good and admirable, right? Admirable. That's also why no IPP should be developing a power project without an understanding of what disco needs this power, an understanding of how transmission will deliver the power to the disco, and an understanding of how the disco will deliver the power to its customers and pay for it, right? Because the purpose should be that, oh, we need X megawatts of power in this location. So let's also understand the project from end to end, even if there are different parties. But what happens in Nigeria is that I decided, oh, I want to build a power plant. I think I can make money doing it. So I go to MBET, and MBET, without following, well, historically, maybe I think that has changed now, without following the laid down requirements in the market rules that require you to understand what disco needs the power, signs the PPA, and then says that we must allocate that PPA across all the discos in the market. Whether the disco says it needs more power, or the disco says this is the best tariff at which I can get this power. So essentially, all risks, in my view, should go to the market, but that also requires a corollary, as a corollary, right, that procurement of IPPs is done very smartly. We're running out of time, so I'll just very quickly go through this slide. Again, we've done quite a bit of talking around the market and revenue. It's important that tariffs are duly collected and payments are made. There's a point there about dispatch, right? And really, what's important is that if we had all the supply we need, then ultimately you have to dispatch the cheapest sources first. In this case, it's renewables typically, particularly hydro. If we have solar as part of our energy mix, it's often the case that for environmental friendliness, renewables are encouraged to be dispatched first. But I think the important thing to note is that let's dispatch in a manner that makes sense. And NEC does have an economic merit order dispatch regulations that's meant to be followed in this case. Again, let's be sure that the project can be properly financed. We properly, at the point of contracting, understand all the construction risk issues and they're properly mitigated as well. The same thing goes for operations and for proper setup, the legal issues around the project. All these matters we've spoken to. So I'm going to just very briefly outline the key contract that will be required for an IPP developer. The first will be a power purchase agreement, right? Which will be between the project company and the off-taker. That really is you could say, in fact, it is the single most important document, right? You know, I've said that ultimately all power is being built for the market, right? And so the PPA is the document by which a party, in many cases, NBA-ICLE, I suspect that over the next few years, we also see DISCOs entering into their own power purchase agreements. And for those of us advising the captive, on captive projects as well. Sorry, not captive now, on, I like to call it inside the fence projects, i.e. a single customer. In fact, that's so, for example, for each grid connected PPA you'll see, you probably will see 20 or 30 that's not related to the grid and just for party A that's trying to buy power from developer B. That PPA is a document that says how much power is required. We'll talk about it in detail in a little bit, where the power plant will be, how the power will be delivered to the customer, and what the service level obligations are. There's a gas sales agreement by which the IPP buys power from the gas supplier. We also have a gas transportation agreement under which the IPP developer. So what the gas seller will typically do is that at this point, typically it's a processing facility from where it connects to NGPTC's facilities. We say that's its delivery point. The power plant might be, so in the case of a client of mine, for example, the power plant is in Ondo State. That delivery point is somewhere in Delta State. So the E&P company delivered the gas to that delivery point, and then the gas transporter under a separate transportation agreement, under which risks associated with transportation are addressed, moves the gas to where the power plant is. There's a grid connection agreement for every grid connected power plant. And what that does is that it sets out the conditions and the parameters for operation for power plants that are connected to TCN's grid, right? Without that agreement, you cannot connect to the TCN grid, which means that the power cannot be dispatched. For projects, of course, that are inside the customer's fence, that will be required. And for embedded projects, what you probably will need is a connection agreement with the DISCO. Ancillary services are some other services which are required for proper operation of the grid, which power plant producers must provide. I mean, a few of them might be things like black start. When we hear about a grid collapse, it means that the grid has gone down completely. What that also means is that typically all the power plants on the grid will shut down because there's no, in most cases, it happens automatically. When the grid is then coming back home, you need a few plants that are connected to it to start the process of energizing the grid. So a black start provider essentially agrees to provide black start services that cost to that. There are a few other ancillary services, reliability must run, frequency control, and the rest of them, which I think, at least for this class, we do not need to talk about. I'm going to skip the transmission line and substation extension agreement, but what we saw in a few projects was, I mentioned that if, for example, there's no TCN facility at the point where the power plant is being built, typically it should be TCN's responsibility to build the line, but TCN will say no. We know where our grid stops, bring your plant to us. So that agreement is typically for doing that. We saw it in a few agreements. I'm not sure if, on a few projects, I'm not sure how that will continue. And of course, there's the EPC contract, which is what the EPC, the engineering procurement and construction contract, which is a contract for the engineering design of the power plant, the procurement of the parts, and of course the construction, the actual putting together of everything and building it. It's also a key contract. If it's properly done or the risks under it are not properly allocated, that's likely to result in a failed project. The LTSA is just to supply spares and other unrelated services for the operation of the power plant. O&M is an agreement, particularly for a developer that's not a technical developer, with a party that's qualified to operate and manage its power plant. the PCOA was an agreement that was designed as part of the protection of security under projects that the federal government issued for, that MBET issued, the federal government of Nigeria issued. Remember again, I said that ultimately all power projects are built for the market, right? What then happened or happens in the case of premature termination of the PPA? Because the idea of the PPA, like all project financed offtake documents, is that over the cash flows from PPA payments over the time of the PPA should pay for the expected equity returns as well as debt, principal, and interest for the project. If for a 20-year PPA, then the project is terminated for any reason, in say year 6, there will be debt, there will be equity. So the put call option agreement simply says that in those circumstances, the developer can put the plants to government to buy, or government can call for the plant to be sold to it for certain payments that are buried, depending on whether the cost for termination is the fault of the seller or the fault of the buyer, or in certain cases, it's a no-fault termination. There are various payments as to what are the various provisions as to what gets paid. But typically, all of the circumstances will require the debt provider to be paid out. Otherwise, it's going to be almost impossible to find financing for power projects. We've spent a bit more time than I thought we would have spent. So we'll just spend, I'll say the next 10 minutes to talk about some of the key PPA provisions, and then we'll round up. So the principal object of a PPA is to sell and buy power, right? And for me, the most important bit of that is to determine whether it's a take or pay PPA, or what I'll call a take and pay PPA. So if I'm going to spend $100 million to develop, say, a 100 megawatts facility, I'm developing it solely for my buyer, in this case, let's say MBET, right? Then I need to be sure that whatever happens, however much power MBET requires, it needs to pay me over the term of the PPA enough to, 1, retire my debt, and 2, make my equity that I'm investing back as well as a reasonable return on it. What that then means is that I have to charge what's called the capacity charge that covers all of that fixed investment, as well as any fixed O&M, operational and maintenance costs that I will incur during the term of that PPA. 3, also, if my gas contract has a take or pay provision, I also have to get under my PPA a corresponding obligation on my off-taker to make those payments, right? So that's why when I say I'm not sure we should be talking about building power plants now. Remember I said we have 13 gigawatts on the grid. I've said we're only dispatching 4,500 of those. Of those 4,500, NBET is not even able to pay, maybe we're around 50% now. I think we're still marginally less than that of what's due. We then procure additional PPAs that require these costs to be paid. We're piling problems upon problems, right? And so for me, the real and most important, and when you're advising your client particularly, even if it's for a PPA for an inside the fence project with an individual customer, the singular most important point is to understand whether there's a firm binding obligation to purchase power and what's the capacity, the minimum. So for example, a power plant might be say 10 megawatts. It might be that the firm take or pay there is only for say 7 or 8, or in some cases I've seen as 6, or it might even be that, particularly if I've already built the power plant, right, and I've, so to speak, either I've recovered my the payments due from another project, or maybe as in many cases it's a government power plant. I can afford to then go into a PPA that says pay me for the energy that you take. But for an IPP that's been developed for the specific PPA, you can't do it without a take-or-pay requirement unless you're taking a risk that, look, there's enough demand in this market to take my power. And I don't think the classic merchant power projects in the US, for example, but this market is not at that stage yet. There will be provisions for power plants. When I'm testing my power plant, the only way to test your power plant is to start it. At that point, you are generating power. There's often a debate with NBA-ICLE whether the power produced during testing should be paid for or not. I mentioned about what happens regarding transmission losses. There's that risk also needs to be allocated. In Nigeria, that's typically allocated to the market. I discuss pay for it, which means you and I will pay for it. All PPAs with embed provide that if because the producer is required to provide ancillary services to TCN, if the amount it's able to generate reduces, it still gets paid as if it's providing the power required. There will be the typical CPs to be performed before the PPA becomes effective. I think the important thing to note is that you can't activate. In fact, your financing will typically require that CPs are met before you can activate the power purchase agreement. Again, there are some standard covenants, reps and warranties and covenants. The typical ones: capacity, ability to perform obligations. What you'd also see in most PPAs these days, particularly because I think it's now standard in Nigerian government agreements, and even all serious, I was going to say international, but I think I'll change that to all serious providers of finance require the anti-corruption provisions, require certain environmental covenants in this kind of agreements. Also, there's also a provision to comply with market rules, good codes, and other relevant regulatory instruments. The PPA will provide for proper maintenance of the power plant, optional maintenance of the power plant, as well as compliance with the appropriate or with good industry practices. Again, because it's also important for the process for building the power plant and making it go live, for it to happen in the sequence that's been agreed. There will be provisions around the scheduled commissioning dates when the plant goes live. There might be liquidated damages for delayed commissioning. There will be provisions for testing the power plant to be sure that the capacity that's contracted can produce it. One of the biggest problems in my view in the Nigerian power market is that NBA-ICLE pays capacity charges to a few power plants without any clarity as to when the plants were last tested to be sure that they're able to provide the capacity that they say they'll provide. So those kind of things are extremely important, particularly for a PPA that has firm capacity charges. It's also important for there to be proper provisions around how the power plant operator will notify the buyer and the party that dispatches the power plant, which we all agree, which we've spoken about, is TCN, or system operator, as to how much power it has available and is able to deliver. If you remember, we said we have 13,000 megawatts on the grid, but only about 7,000, I think 800 is available, right? So there are all kinds of reasons why a power plant might be installed but not available. But what should happen is that for every hour in every day, the power plant operator should do what's called a day-ahead nomination. Let the system operator know how much power it's able to deliver to the grid for each hour. The purpose of the PPA is to sell power. That commodity that's being sold must be measured, and the only way that's done is through the metering. There's a metering code for the industry which meters are required to satisfy. It's important also to understand when that commodity is handed over to the buyer. In the case of a PPA for the Nigerian power market, that happens when, so TCN is the agent of the buyers for the purpose of taking the power, Please let me withdraw that. I don't want to use agent so that also discos aren't compelled to take responsibility for TCN actions. But essentially, once the power producer puts the power plant on the TCN, sorry, puts the power produced on the TCN grid, then title and risk has passed to NBT, i.e., it's now the obligation, whatever happens to the power is on the off-taker. So any line losses that happens on the TCN grid is TCN's, it's the disco's problem really. I think there's an 8% transmission loss factor assumption that's built into the tariff. So that's how that stays. Of course, the PPA will provide for billing, and the way it's done is that the market operator issues settlement statements every month. We spoke yesterday about a meter being at every grid supply point, right? But every point at which you're putting power on the grid and every point at which you're taking power off the grid. So what the system operator does in the market every month is to have those meters read. Based on that, the market operator issues settlement statements. The parties come back if they think there are problems with that statement, and based on that, the final settlement statement is issued on the basis of which payments are made. Provisions are made for default early termination. Of course, it will be usual to provide for a period for cure, and then what then happens in the event of early termination. In some PPAs, you find that if, for example, you give me a 10-year PPA, if you terminate in year 5, there might be provisions that say, okay, you pay me, you make me a payout, a termination payout, right? Which will be graduated depending on what year termination is. Or in the case of the NBA PPAs, it might be a put and call option arrangement. Force majeure, we lawyers are fairly comfortable with that. There are a number of specific force majeure events that are provided for in the MBT PPAs. Choice of law, dispute resolution as well. All MBT PPAs, my recommendation is that any PPA for performance in Nigeria really should be governed by Nigerian law. And typically, for many of the internationally financed PPAs, what we see for dispute resolution is international arbitration, typically at the ICC. So I think we should stop here. Our time is virtually gone. We'll take a few questions and then I'll just round up. So Mabel, please.
Thank you so much. I think I like the part where you ran us through the contracts, the key clauses. From Asiri, he says, many thanks for this impactful webinar. This person's name is not showing. He says, mine is a request. Can the registered participants be available with the slides of the presentation? Thank you. The Institute to take care of all this. Tile says, as a thought leader in the energy industry, do you think the failure of NERC to grant a license to an independent distributor in respect of geographical area that has already been
can you repeat that? I didn't quite hear the last comment.
So he says, as a thought leader in the energy industry, do you think the failure of the NERC to grant a license to an independent distributor in respect of a geographical area that has already been granted to an existing DISCO raise a competition concern that should be investigated by the FCC? This is in view of the protection you said is afforded to DISCOs.
Okay. On the slides, yes, I'll make them, we'll send them to the secretariat, and I suspect the secretariat will distribute. That's fine. Let me take the second half of that question first. Given what our FCCP Act says, it's clear that there should be some kind of correlation and coordination, sorry, that's what I wanted to use, between the FCCP and NERC. How that gets done for competition-related matters is really very important, and is extremely important when you think that what the FCCP Act, which is later in time, says is that yes, they should coordinate, but ultimately, once it's a competition matter, the FCCP has priorities to speak. So, in every area that there's a competition issue between in the sector, I think it's important that the NERC and the FCCP get in a room and agree what the rules are and what the basis for the rules should be. Now, as regards whether or not and in what circumstances IEDNs should be licensed, I actually think the greater failure is not NERC. There are failures all around there. There are failures with the discos, there are failures with NERC. But I think the greater failure is on the government side. I'll explain why. And NERC is not government, please. It's not. I say that all the time. NERC is not government. The party competition, monopoly, exclusivity are all matters of policy. And the Minister of Power has the right, I was going to say Minister of Power has the power. Yes, it does have the power to issue directives of a general nature to NERC. The Federal Executive Council has the right to determine policy for the federal government, for Nigeria, particularly including for the power sector. There is an economic argument to be made for lines or wires being monopolies. And that is that one line is cheaper than two sets of lines. But that argument only holds to the extent that the distributor or the distribution company, or even TCN in case of transmission, is behaving in a manner that is not abusive of its monopoly position, right? So the work of laying out the rules for what's an abuse of a monopoly, right, is policy work that government should do and lay out clearly. And so that there is a policy basis for NERC to exercise its powers under Section 76 of the EPSR Act, which says that granting one party a license does not mean the party has a monopoly, right? So the rules are not, I mean, the economic basis for the argument is not straightforward, but government should come out and lay clearly. You cannot protect a monopoly for the sake of the monopolist. That's wrong, right? But there should be rules that justify departure from the monopoly. In what instances would the disco, in what kind of disco failures would enable you to grant an IEDN license where there is a disco? Until government clearly comes up with that policy, then NERC really will continue to do what it does, which in my view is failing to address the question. And it's a policy conversation to be had, not a regulatory one, in my view.
Thank you.
Hello?
This is from Ose. It says, I'm generally excited about this lecture on energy law, but sometimes I wonder if Nigeria has any future plans towards sustainable and clean energy so as to drastically reduce our carbon impact.
Yes, we have renewable energy targets, and then we have all kinds of ambitious plans, one in that regard, and just generally, including, for example, for nuclear energy, as we spoke about yesterday. So we have plans. How realistic those plans are and how topical they are in the context of our current state of our energy sector is what I don't know. But there are plans in the books, and there are quite a number of policies issued by the Ministry of Environment, and I think even Power, that address those.
Thank you. Introductory says this is quite an educative session to be a part of. There are lots of accolades here for you. From Emmanuel, it says, I don't understand the sense in GenCos producing far too much of electricity when both the transmission and in fact the disco cannot take and consume such volume, which sometimes leads to collapses.
Very good question. We've addressed many parts of it. So the GenCos are able to produce. That's why they have 13 gig installed. But because we must always instantaneously balance what's generated and what's evacuated and delivered, it means for most of the time, they're not able to produce. Now, what should normally happen for a properly operated system is that there should be SCADA, electronic communication that automatically balances. When more consumption is needed, it will just signal to a particular power plant to generate more. When you need less, it will signal to it to reduce generation. But unfortunately, I understand that the National Control Center in Osogbo still does a lot of these activities by telephones, right? You're calling the plant in Delta State, hey, shut down, can put down one turbine, reduce the load on that turbine. That's definitely one of the factors that contributes to system collapses, correct? Because ultimately, when you're not balancing what's on with what's off, and when so if there's a trip in a relay somewhere, for example, and a substantial part of the grid goes down suddenly, what's likely to happen is that it affects the entire grid. So yes, until we invest in distribution capacity and transmission capacity to be able to take more power from the grid, there's always going to be more on the generation side. And the important thing is we have to implement SCADA really, so that automatically the controls are in place to say when, and that will minimize grid collapses.
Thank you. I'll just take a few of the comments here. Many thanks for this impactful webinar. Thank you, sir. You've done so well. Awesome presentation. Thank you very much, Shola, for an insightful presentation. I appreciate this. Excellent. Thanks for elucidating session. It's been more technical than I thought. Many thanks, warm regards. And so we have a lot of all this thank you and accolades coming to you. Thank you so very much. That'll be all from my end.
Okay, thank you very much, everyone, for attending. Shola, what a brilliant presentation. Not in any way less than what we expected. That's why we call you a master in that space. But thank you very much for breaking it down so effortlessly and so easily for everybody. I know how busy you are generally. We don't take it for granted that you found the time to facilitate this particular session. Regarding delegates who've been asking questions around the course materials and slides, just want to let you know that we're going to circulate them to all the participants and even to those who did not participate. And part of the idea behind the trainings we have is just to make sure that we try to encourage people to get interested in more than they do and to deepen the knowledge in what they do. The Institute of Continuing Legal Education will gravitate more towards mandatory continuing legal education. But in the meantime, our focus is on making the trainings affordable, available, and accessible. So I hope you found the session today illuminating. Thank you very much for being part of today's discussion, and God bless you all. Yeah, I think that brings the session to a close. Mabel, can you hear me?
Yes, I can hear you.
Okay, good. So that brings the session to a close.
Thank you.